Hello everyone, welcome to the online session of Manolo classes. My name is Dinesh Kumar. I am former assistant professor of law at Campus Law Center, Law Faculty, Delhi University. Right now I am working as an academic head of Manolo classes. Today I will discuss with you one of the path-breaking judgment of Honorable Punjab and Haryana High Court, that is Chandigarh Law Society versus Bar Council of India and others, dated 4th December 2020. In this case, Honorable High Court has shown its great concern regarding the elevation of standard of legal education in India, and Honorable Court itself observed that many new entrants in the legal profession are not up to the mark in drafting the petitions or assisting the court. Some of them even are not confident enough to speak the court language. Now we come to the case specifically. The name of the case is the Chandigarh Educational Society versus Bar Council of India and others. What happened in this case? In this case, the petitioner, that is the Chandigarh Educational Society, bought some land for the purpose of establishing its law college. In this judgment, we will deal with the various constitutional and legal provisions. Number 1, Article 19, Clause 1, Subclause G of the Constitution of India, which authorizes to every citizen of India to carry out any occupation, trade, business, etc. Article 19 Clause 6, which imposes the reasonable restrictions upon these rights. Article 226, which provides that if the right of any person has been violated, then that person can approach directly to the Honorable High Court by virtue of Article 226 of Constitution of India. In this case, we will also discuss Section 7, Subclause 1, Subclause H of Advocates Act 1961 and Rule 11 of Legal Education Rules 2008. As far as the facts of this case is concerned, in this case, the petitioner, that is the Chandigarh Educational Society, hereinafter referred to as the society, purchased the land measuring 5.625 acres during 2017 and 18 for establishing a law college under the name Chandigarh Law College. Petitioner also passed a resolution on 15th January 2018 for setting up a new college with the intakes of 240 students from the academic session 2020 to 2021 onwards. Petitioner also completed all the necessary legal formalities for getting the recognitions from the respondent, that is the Bar Council of India. But the respondent put 3 years moratorium on granting the recognition. It is necessary to elevate the level of legal education in the country and also to prevent the mushrooming of centers of legal educations. Petitioner approached to Honorable High Court under Article 226 of Constitution of India and prayed for issuing the writ of certiorari for the purpose of quashing the resolution passed by the respondent, and also requested to issue the writ of mandamus to the respondent to grant the recognitions to the law institute of the petitioner. As far as the legal issue in this case is concerned, the legal issue in this case was whether the Bar Council of India can legally impose moratorium qua opening of new law educational institutes under Section 7, Subsection 1, Subclause H of the Advocates Act 1961 and its relevant rules. In this case, petitioner contended that respondent is not empowered under the Advocates Act or under the relevant rules which have been framed under the Advocates Act to impose such moratorium on the establishment of new law colleges, as it only derives the regulatory powers from Section 7, subsection 1, subclause H of the Advocates Act 1961 and its Rule 11 of the Legal Education Rules 2008. Respondent thus has violated the fundamental rights of the petitioner under Article 19, subclause 1, subclause G of the Constitution of India. Article 19, subclause 1, subclause G of the Constitution of India authorizes every citizen of India to do any occupation, trade, business, etc. As far as the contention of the respondent in this case is concerned, it contended that Section 7, subsection 1, subclause H of Advocates Act 1961 and Rule 11 of Education Rule 2008 empowers it to regulate the legal education in the country and also empowers it to grant the recognition to new law colleges in the country. Under its regulatory power, it also has the power to impose the moratorium on the establishment of new law colleges in India. So, it only exercises its power under Section 7, subsection 1, subclause H of the Advocates Act 1961. Read with Rule 11 of Legal Education Rule 2008. Honorable High Court, after analyzing the provision of Section 7, subsection 1, subclause H of the Advocates Act 1961 and Rule 11 of Legal Education Rules 2008 came to the conclusion that these both provisions only authorizes the respondent to regulate the law education in India and it does not empower the respondent to put the moratorium on the establishment of new law colleges in India. So, respondent in this case, by imposing the moratorium, has exceeded its power and acted ultra-virusly. Means imposing the moratorium is beyond the power of the respondent in this case. So, the moratorium imposed by the respondent is null and void. Honorable High Court in this case also referred to one of the landmark judgment of Honorable Supreme Court, that is TMA Pai Foundation and others versus State of Karnataka and others, dated 31st October 2002. In this case, Honorable Supreme Court held that right to establish educational institute is a fundamental right under Part 3rd of the Constitution of India, and this fundamental right can only be taken away by anyone only according to the procedure established by law or limitations imposed either by the Constitution itself or by any other law for the time being in force. That's all for today's lecture. We at Manu Law Classes provides the legal education for various courses like CLAT, AILET and upcoming UGC, NET and UPSC law optional subject. We have a dedicated team who work hard for the betterment of the student or for the success of the students. We will come soon with the next path-breaking judgment of Honorable High Court or of Honorable Supreme Court. Till then, wish you all the best. Thank you very much.